It is their submission that both courts stated such discrepancies, if found, are to be addressed and or rectified by an election court. They emphasize that without prejudice, Article 81 of the Constitution, as read together with Article 86 of the Constitution, outline the guiding principles in regard to the conduct of elections. In this regard, the petitioners made reference to the minor KI decision that relied upon Asanali Joho's case, petition number 10 of 2013, and the case of Suleiman Said Shabal, election petition number 8 of 2013, that defined the term declaration. During the highlighting of submissions, Mr. Willis Otieno, learned counsel for the petitioner, added that the questions for clarification belong to the Court of Appeal, as the Supreme Court merely recognized the effect of the Court of Appeal decision. He submitted that the questions now being raised were indeed posed to counsel by the learned Justice Kiage, Judge of Appeal, during the hearing before the Court of Appeal, and the role of the second respondent was well circumscribed in the minor KI decision, which, as all the answers, if only the first and the second respondents had faithfully read that judgment. In any event, counsel added that the first and second respondents are not prevented from petitioning the election court in the event that they encountered any discrepancies and mentioned by them. On this part, Professor Ben Sihanya, another advocate for the petitioners, submitted that this court lacks inherent jurisdiction, the application being neither a presidential election petition, an advisory opinion, nor an appeal, unless parties approach this court through the back door, by way of review, interpretation, or clarification, or in any circumstances granting this court jurisdiction. Counsel thus submitted that the application does not fall within the ambit of Section 21(4) of the Supreme Court Act, and there is therefore nothing for the court to correct in its judgment. Counsel added that just like in 2013, in the presidential election petition before it, the court can, on its own motion, correct its decision in the event there was such need and basis for it. He submitted that the matter is now res judicata, the court having been functus official. He further urged the court to take judicial notice of the respondent's consistency in non-compliance with law and the fact that the Court of Appeal in the minor KI decision took time to rebuke the commission for so doing. In conclusion, counsel urged that being a court of justice and equity, he who comes to court must come with clean hands, and thus urged the court to dismiss the present application with costs